Greetings from London. I'm sorry not to be with you and grateful for this opportunity to participate. Now, when the fate of migrants at sea is discussed, it's common for the implementation of international law to be invoked as a remedy. Today, I'd like to interrogate the assumptions about the value of international law that lie behind this. What is at stake in viewing international law as a solution to current challenges relating to migrants at sea? Due to time limitations, I'll focus on people moving to escape human rights abuses. It's important, first of all, to acknowledge how law sometimes plays a major role in preventing migrants from obtaining protection from human rights abuses. Most fundamentally, it does this by allowing other states, where protection might be forthcoming, to control their borders, both at their side of these borders and outside this, at ports of exit, whether directly through the extraterritorial postings of immigration officials or indirectly via the operation of legal sanctions against carriers. So one reason why people pay smugglers significant amounts of money to travel on unseaworthy vessels is because they're legally prohibited via these visa restrictions and carrier sanctions from taking the safer and usually much cheaper options of regular sea vessels and flights. This is where the term illegal migrant, much hated by refugee advocates, no person should be labelled illegal, reflects the general international legal proposition that a state has a right to control its borders, and individuals who cross such borders in contravention of this are, by international legal definition, illegal migrants. The term is helpful in reminding us how international law is directly involved in determining the dangerous and expensive nature of sea crossings. One might say then that certain state entitlements in international law are very much part of the problem. But there are of course other areas of law being invoked as the solution, notably refugee law and human rights law. Refugee advocates are of course calling for states to comply with their obligations here. It's suggested that if this happened, things would improve. Indeed, perhaps even the operation of the general legal entitlements of states to control their borders might be somehow modified if these other rules were followed. The main relevant substantive obligation is that of non-refoulement, the requirement not to send someone back to face human rights abuse, which exists expressly in the Refugee and Torture Conventions and has been read into other general human rights instruments. Here, it's instructive to consider what is not covered by the obligation. In the first place, the obligation only applies to individuals once they've managed to reach or cross the border of the state's territory, or, at least as far as the obligation in human rights law is concerned, if they fall within the control of that state exercised extraterritorially. States can therefore try to prevent this obligation from arising through the operation of the legal arrangements of carrier sanctions and visa restrictions. In the second place, once individuals are outside the state where they suffered or feared human rights abuse and are in the territory or under the extraterritorial control of another state, then as far as the non-refoulement obligation is concerned, they have no right to move on to another state where the material conditions may be better. So, people who've escaped Syria and are in camps in Lebanon and Turkey, or have managed to cross over to Greece, have no general right based on the obligation to move further, as many wish. By the same token, there's no requirement here on the part of other states to allow these people to travel to their countries to be given protection there. An exception to this, insofar as it's still being honoured and may survive in the future, is within the Schengen area of the EU, where there's free movement of people between countries. This is why, until borders began to be closed, migrants who'd taken the Balkan route between Greece and either Croatia and Hungary and wanted to move further north and west, for example to Germany, were potentially able to do so. Even here, though, the law allows for extraordinary suspensions, with the reintroduction of border controls, something which, as we know, was done by certain EU states. And to take advantage of it when it wasn't suspended, refugees who managed to get to Greece by sea had to initially make a further irregular journey without any legal entitlement, either through the non-Schengen EU countries of Bulgaria and Romania or the non-EU former Yugoslav states. More generally, outside these arrangements, there's no such right of movement to and across borders in order to be able to make asylum claims. So, of course, there's no general right to travel for the purposes of obtaining refugee protection into the Schengen zone, or indeed to the EU generally, from outside it, for example from Turkey to Greece or from Libya to Italy. Hence the perilous requirement of an irregular sea crossing. It's also worth noting the EU system of common asylum law, which under the Dublin regulation seeks to ensure that individuals entitled to protection are normally given it in the first EU state they enter. Other European states are generally entitled to send such individuals back to that first state. So even when Schengen free movement is in normal operation, individuals who've managed to move because of it can be sent back to their original state of entry. The combined effect of the normal operation of these legal provisions, both generally and within the EU, is to ensure that the responsibility of hosting individuals fleeing human rights abuses falls disproportionately on a minority of states. Moreover, these states are typically the least able, in material terms, to discharge their legal duty. Despite what some in Europe imagine in terms of the numbers, even now, of refugees in that continent, most people fleeing across borders to escape human rights abuses move from one developing country to another. According to the Office of the UN High Commissioner for Refugees, UNHCR, developing countries host 86% of the world's refugees. The law provides a means for refugees to be compelled to stay in these developing countries by enabling more economically advantaged states to prevent regular means of travel to their territories, doing so via carrier sanctions and visa restrictions. Moreover, these developed states, by virtue of their advantageous position, are able, of course, to maximise the benefits of the prevention possibilities, leveraging their economic significance to the airline industry when seeking to impose and implement carrier sanctions. Necessarily, the only way of challenging this unequal legal system of refugee protection is either through individuals deciding to move illegally and dangerously, or states choosing to waive their legal privileges or go beyond their limited legal obligations. In other words, there has to be a departure from law, either through violation in the case of refugees, or by doing things the law doesn't require in the case of states. The disproportionate regime of refugee protection globally feeds into and is replicated by the system in Europe. The law forces refugees from and travelling through Libya and from Syria to resort to the irregular and dangerous sea crossings that, even if successful, leave them in the poorer southern European countries of Italy and Greece, and then keeps them there absent exceptional measures, whether further irregular migration into the rest of Europe, or the remarkable recent arrangement whereby arrivals in Greece will be sent back to Turkey on the basis of swaps involving other refugees in Turkey being transferred to European states. A further important feature of this system is that states exercising their legal entitlement to keep refugees out are not subject to a legal requirement to provide assistance to those other states who, because of the non-entrée actions, are faced with a disproportionate responsibility to host refugees. Of course, developed states may choose to waive their legal privileges and/or act beyond what is required by international law. So we see Germany initially deciding to suspend its Dublin entitlements and accept refugees already present elsewhere in the EU. Other European states decided to accept the direct transfer of certain refugees from the camps in Lebanon and Turkey, and to provide funding to improve the material conditions in those camps, explaining these measures as ways of preventing the need for individuals to make the perilous sea crossing. More broadly, it's instructive to consider how UNHCR, which is usually given the task of running refugee camps in developing countries, is funded. In the main, this is through not the general UN budget, but rather annual rounds of pledges from and special appeals to developed countries. In this context, we might understand the work of the agency running refugee camps as a means of richer countries assisting developing states in which the camps are located. More broadly, we might view this as an alternative means of securing the welfare of the individuals in the camps, compared to the option of such individuals having a legal right to travel to wealthier countries to secure asylum there. It might be said then that the legally enabled policy of keeping most refugees out of developed countries can be compatible with the protection of these refugees. If complemented by the provision of material assistance to refugee camps and mitigated by exceptionally allowing some refugees in. This argument has to reckon with the fact that the complementary protection arrangements are ultimately discretionary. They're left to political will, not subject to legal sanction. This creates the possibility that they will be modest, arbitrary, and distorted by considerations other than the needs of the individuals concerned. We can see indeed that this possibility has been realised in fact. The German government's decision to be more welcoming than it's legally required to be, already atypical when compared to most other European states, is no longer as popular in that country as it once was, as gains by anti-immigrant parties in the recent elections seem to indicate. The decision by certain other European states to take some Syrian refugees direct from the camps has involved a relatively limited number of people, a shamefully low number in the case of my own country, the UK. More broadly, the way UNHCR financing is configured, precariously dependent on the annual decisions of donor states, has led to the charge by some that this has distorted the policies of the organisation to suit the wishes of donor states to contain refugees, warehousing them outside the developed world. And in this and other refugee assistance, we see OECD states sometimes raiding existing international development budgets, thereby reducing overall general aid provision, potentially worsening the material conditions in the developing world which contribute to forced migration in the first place. What is posited as a remedy to a problem in one area comes at the expense of efforts in another area that actually address part of the cause of the problem in the first area. This also enables OECD states to double dip in the discourse of international humanitarianism. They use the same resources to claim to be both meeting their aid targets, including the figure of 0.7% of GDP that has been invoked for some time in international law, and providing supposedly extra assistance to deal with the exceptional current migration situation. To conclude then, when considering the fate of migrants at sea, we have to face up to how international law may be, at best, incapable of making much of a positive difference, and, at worst, partly determinative of the broader structural factors that mediate the decisions people make to take such dangerous actions. Thank you.